21-169-897. This is tox testing versus City of Detroit. Today is a time set for a pretrial conference. Court previously signed a scheduling order. Your appearance, please, for the plaintiff in this matter.
Good morning, Your Honor. Michelle Khan appearing on behalf of the plaintiff, P75585.
All right, good morning to you, Ms. Khan. For the City of Detroit, your appearance at this time, please.
Morning, Your Honor. Mary Beth Cobbs, P40080, appearing on behalf of the City of Detroit. And we have two other counsel in the Zoom courtroom, Your Honor, regarding this matter.
All right, thank you, Ms. Cobbs. Who else do I have here? Your appearance, please.
Morning, Your Honor. Brian Kingsley, P31091, appearing for defendant Smart.
Morning, Judge Coleman. My name is Tim O'Connor, and I'm appearing on behalf of defendant MAPF. And Your Honor, I think Brian Kingsley will tell us more, but he and I should not be in yet. We're waiting for an order of dismissal as to our two clients, but I'll leave it at that.
Yes, Your Honor. At our last pre-trial conference.
Mr. O'Connor.
I'm sorry, sir.
Give us your P number on the record if you want.
Yes, 40517.
All right, thank you, counsel. And Mr. Kingsley is on you.
Yes, Your Honor. At our last pretrial conference of January 13, the parties agreed that defendants Smart and MAIPF were not proper defendants in the case, and that the only remaining defendant should be the City of Detroit. The court instructed us to submit an order to the court which aligned parties and dismissed MAIPF and Smart. All parties stipulated to that. I submitted it to the court, but for whatever reason, it did not get to the court's attention. This morning, I spoke with Ms. Hunter and emailed her the order again, and she acknowledged receipt. So you may have it in front of you at this time.
I do, and I have just signed that order. For some reason, it did not populate to the court's file, but thanks for the email, because now I have received it and I've signed that order, and the dismissals are in fact based upon terms set forth in the stipulated order.
Your Honor, may I ask if the court will be providing 2 copies to the parties?
Absolutely. Absolutely. Those will be sent out in mail. My clerk's going to take care of that today.
Thank you very much, Your Honor.
Thank you. Good day to all. And Ms. Cobb and Ms. Khan, where are things I think you're going to remain in this matter? What's going on? What do we need to do next?
I believe defendant has their motion for summary disposition up for today, Your Honor, so we have not had any settlement discussions.
That is accurate, Your Honor.
Let's see here.
Your Honor, do we have the court's permission for myself and Mr. O'Connor to leave the meeting at this time, since we're dismissed?
Yes, you are dismissed out of the case and you are excused at this time.
Thank you very much, Your Honor.
All right. And I'm just getting my hands on the defendant's motion for summary disposition. Ms. Khan, did you have opportunity to file a written response to the same?
I did, Your Honor, and I had it mailed to the court. If the court would like, I can also email you a copy or fax a copy.
It does appear that I do not have You might have to read this one. You keep
Oh, yeah.
all this the same.
Okay, all right.
All right, so no, I don't have the written response at this time. So why don't you get that to me and let's set a date so that I can this motion. So maybe 2 weeks out. At the end of this month.
I took the extra time. Think you doing that, April? All the love for today. Okay. April the first.
April 4th. I'll hear this motion on April the 4th. So why don't you, Ms. Khan, get that over to me, get the response over to me as soon as possible.
Okay, Your Honor, can I fax it to you or does the court need it mailed?
You can email it. if you will.
Email, okay,
And so you would email that to Latifah, LATIFAH .Hunter @36districtcourt.org.
okay. Okay, thank you very much, Your Honor. I will do that.
That's gonna be April the 4th, and that's gonna be 9:30 a.m.
Thank you, Your Honor.
All right, thank you, Ms. Cobb.
Thank you.
Thank-
All right, this is case number 21-240-315. This is Jessica Floyd versus the budget lot. Is this?
Yeah, but she said it was settled. She came on, she said she was at first, but she said it is settled.
The court has received information that this case has been resolved between the parties. And they've asked the court to enter an order dismissing the matter where the parties have reached a resolution. The matter will be dismissed at this time. The court now calls case number 21-64776. This is for Transport Incorporated and For Your Recovery Therapy LLC and Gravity Imaging LLC versus Michigan Automobile Insurance Placement Facility. Your appearance regarding this matter.
Good morning, Your Honor. Attorney Marcello Pedini, P number 76282, appearing on behalf of plaintiffs.
Thank you, Mr. Dean. And for the defendant in this matter.
Good morning, Your Honor. Talitha Mahome, P number 79890 on behalf of MAIPF in this matter.
Thank you, Ms. Long. All right, so I sent this on for a pretrial, and I remember this case coming up a couple of times, but my memory is not real specific on exactly where you are regarding this matter. So somebody update.
Sure, Your Honor. We have been trying to get the deposition of claimant in this matter. She appeared one time, but did not complete the deposition. She got angry with the questions and logged off Zoom. Your Honor did sign an order compelling the deposition by February 28th. We scheduled that deposition. She was personally served and she did not appear for the deposition. And today was the date also scheduled for a show cause hearing in case she didn't appear for the deposition. And it does not appear that she is on this Zoom call either.
All right, and let me just check and see, do I have Sakia Lindsay Harvey on the Zoom anywhere? If you're on the Zoom, please say something at this time. All right, and I'm receiving no response. I did, in the order that was issued by the court, provide that this was a show cause date if the defendant did not appear, and that she was directed to the claimant, and that she was directed to appear on today's date for that show cause if she elected or failed to appear for the deposition. Mr. Medini, anything you wish to bring to this discussion, sir, at this time?
Just that plaintiffs, I know this may not be the time and place, but plaintiffs will in the future continue to argue that Miss Sakia Lindsay Harvey's absence does not affect the provider's right to their own independent action, and pursuant to the new no fault that they have the right to bring their own action. So we'll just continue to, if you will, stand on that hill, if you will.
All right, obviously that issue is in fact preserved. Your pleasure at this time, Ms. Mahone, regarding the show cause at this time.
Yes, Your Honor, we just ask that you enter the order holding Miss Sakia Harvey in contempt.
All right, the court will find that the claimant, Ms. Sakia Lindsay Harvey, is in contempt of this court, having failed to appear for the deposition that was scheduled in this matter, and having in the alternative failed to appear at this court's hearing. The order was sent to Ms. Lindsay Harvey as well, so that she would be notified of both events, and she has elected to not be a part of the occasion. Accordingly, the court now will issue a bench warrant based upon the show cause. The court will set bond on the bench warrant $3,000. Counsel, I'll sign a bench warrant upon your presenting to the court, and of course you take it to the Wayne County Sheriff's Office so that they can move forward in that regard. As it relates to the balance of this case, I know that testimony seems to be a crucial part of this case from the defendant's perspective. Are there any other issues that we can move on at this time?
I don't believe so, Your Honor.
All right, Mr. Bethany, anything?
No, Your Honor.
All right, so let's get that bench warrant to me right away. Are there any outstanding other discovery issues or anything else that parties are seeking that has not been received at this point?
No, Your Honor, I show that our discovery is complete from plaintiff at this point.
Nothing on plaintiff's end either, I believe, Your Honor.
All right, thank you. So what I'm going to do is I will go ahead and I'll go ahead and adjourn it over for just over 30 days to see if we can get this person in under the court's authority, so that we can kind of get that testimony and see what bearing it may have on the disposition of this case. So the new date is going to be April.
A little later, 11.
April 11th, 4/11, 2022, and that's going to be at 9:45 a.m.
Wonderful. Thank you, Your Honor.
Madam Counsel, you can send that order. You can send that order by way of email if you wish to do so. So that
Yes, Your
I can see right away. So you have Ms. Hunter's email address, correct?
Yes, I do.
All right, thank you. All right, so
Great.
see you on the 11th of April. Okay.
Thank you, Your Honor.
Thank you, Your Honor.
All right, this is case number 21-162-348. This is Michigan First Rehab versus Nationwide Mutual Fire Insurance. The matter is before the court set on for a pretrial conference on today's date. Your appearance for the plaintiff, please.
Good morning, Your Honor. Connor Clordy, P84485, appearing on behalf of the plaintiff, Michigan First Rehab.
Morning, Your Honor. Good morning. Your appearance, sir.
Good morning, Your Honor. Nicholas Ackerman, P number 85192, appearing on behalf of defendant Nationwide Mutual Fire Insurance Company for today's pretrial conference.
Thank you, Mr. Ackerman. Good morning to both of you, gentlemen.
Good morning.
I think I set a discovery order on this case previously. Is that correct?
Correct. And we finally had the opportunity to take the underlying claimant, Ronald Dawson's deposition on February 23rd. And now we're just asking for a little bit more time to review same so we can wrap this matter up quickly.
Or that sounds like makes sense to you, sir.
What do we mean by review, Your Honor? Are you asking for a brief adjournment, Mr. Ackerman?
Yeah, just a brief adjourn to have another pretrial scheduled.
I'm not opposed to that. That sounds agreeable.
All right. So the 4th of April works out okay. If I give you about a few weeks, or do you need about a month?
4th of April is fine with me if it's okay with plaintiff's counsel.
That works for us.
So we'll set it at 4/4/22, 9:45 a.m.
9:40.
And we'll take a look at everything at that time. Gentlemen, good to see the progress that's being made, and let's see where we are at the next year.
Thank you very much, Your Honor.
Thank you, Your Honor. Thank you, Mr. Ackerman.
Of course, thank you. Bye-bye.
Court finds good cause to adjourn. All right, the court calls case number 21-140-786. This is Michigan Comprehensive Spine and Rehab versus City of Detroit. And your appearance for comprehensive, please, Michigan Comprehensive.
Yes, Philip Jaffe on behalf of the plaintiff P25997.
All right, and your appearance for City of Detroit, please.
Good morning, Your Honor. Alfred Ashley on behalf of defendant P82536.
All right, good morning to you as well, sir. Of course, I know that the motion for summary disposition is pending before this court, and I adjourned it on a previous occasion to give counsel an opportunity to file a response or otherwise act in regard to this motion. So where are we at this time? Have we resolved this?
No, we've not, Your Honor. And there was a judge's copy of a reply to plaintiff's response that was dropped off. I don't know if the court has got a chance to review that yet.
I'm looking.
Okay.
I have not. I have seen the plaintiff's answer to the motion. I don't see the reply to the answer. But I'm sure that you're perfectly capable of telling me what that is at the appropriate time.
Sure. So,
you may go forward at this time with your motion at this time.
okay, Your Honor, this is defendant's motion for summary disposition pursuant to C10 and C8. This motion in this case concerns treatment allegedly provided to the underlying claimant, Miss Elizabeth Robinson Smith, 4 years after her alleged injuries suffered in a motor vehicle accident on a City of Detroit bus. We deposed plaintiff's doctor and representative in a Deuces Takem deposition, and as I articulated in our motion, Mr. Dillon was unable to provide any non-speculative evidence that the alleged treatment was causally related to the 2016 motor vehicle accident. Dr. Dillon failed to produce the requested documents that he now attempts to rely on in his response to defendant's motion for summary disposition. Further, he also testified that it was just an additional service. There's no evidence that this was required, medically necessary, or anything of that nature. In fact, the plaintiff's response to defendant's motion explicitly concedes that the alleged treatment at issue was not related to the 2016 motor vehicle accident. Furthermore, plaintiff didn't respond to defendant's motion with substantively admissible evidence under MRE 803 subsection 4. Hearsay statements contained in medical records may be admissible for the purpose, if those statements were made for the purpose of treatment or diagnosis. Plaintiff attempts to present those records to try to show that there was a motor vehicle accident, or as it relates to the motor vehicle accident. Defendant presents that those are not for the purpose of treatment or diagnosis and should not be considered by the court. Further, plaintiff presents absolutely no evidence from the underlying claimant that the treatment was even received, let alone related to the underlying motor vehicle accident 4 years earlier. And I'll allow plaintiff to respond. Plaintiff to respond.
Thank you, Mr. Jaffe, you may have this time, sir.
Sure, thank you. I think what the defendant is saying is that there's no factual basis for this complaint to go forward. And, much to the contrary, as we've shown, not only was Dr. Dillon's deposition taken by the defendant, and Dr. Dillon is the owner of the plaintiff and also the owner of another medical provider, Farmbrook Interventional Pain. This particular patient was involved in a bus accident. The bus accident incident report I've attached to our response. Following the bus accident injury, the particular patient began treating at Farmbrook Interventional Pain for a cervical and a lumbar radiculopathy. She treated there for some time. During that treatment period, Dr. Dillon, who was her treating doctor, prescribed for her that she undergo a series of epidural steroid injections. As a matter of fact, she had 3 of them in 2020. The only involvement of plaintiff in this case, Michigan Comprehensive Spine, is that Michigan Comprehensive Spine provided the anesthesia to this patient for the 3 epidural steroid injections that were provided to the patient by Farmbrook. Now, Dr. Dillon, as I said, owns both Farmbrook and plaintiff Michigan Comprehensive Spine. So at the time of the doctor's deposition a few months ago, counsel was asking him, I think counsel may have been confused at the time or didn't understand the relationship between Farmbrook and Michigan Comprehensive, because Michigan Comprehensive did not treat this patient as Farmbrook did. Michigan Comprehensive did not diagnose the injury for this patient. Farmbrook did through Dr. Dillon. All Michigan Comprehensive did is during the epidural procedures, they were the anesthesia provider for the patient. So Dr. Dillon during the deposition was always asking counsel, well, are you asking me about the treatment that Farmbrook provided and the diagnosis that Farmbrook made, or are you strictly asking me about what involvement Michigan Comprehensive had. And Mr. Ashew would always say, no, I'm talking about Michigan Comprehensive. And the doctor would respond in that context with providing anesthesia services only. But even through all of that miscommunication between counsel and the witness, Dr. Dillon was able to testify, as I've pointed out in my response, that, and as a matter of fact, it's in his transcript that I've attached, page 36 and 37 of the transcript, where he said that Dr. Dillon said that he had a factual basis to believe, based upon the patient history taken and the Farmbrook medical records, which he had in front of him, that the patient was involved in a bus accident. And based on the Farmbrook records that he had in front, that the patient gave a history of being involved in a bus accident injury at the time of her very first appointment at Farmbrook. And the doctor went on to testify that there was a connection between the bus injury, between the bus accident and the injury caused to the patient and the treatment that the patient received. That's in the transcript. There's no factual dispute about that. Now, in terms of this stuff about hearsay, this was Dr. Dillon, the patient's treating doctor, testifying from his own records, and that is not hearsay. And that's admissible evidence, both in a deposition at the time of trial and to be used for purposes of responding to a summary disposition motion. So at the very least, without arguing more, there is a factual issue, apparently, between the bus accident, the injury caused to patient, and the treatment provided. And as such, the defendant's motion should fail, as there is a factual issue presented based on plaintiff's response and the documentary evidence submitted and the deposition transcript of Dr. Dillon, which makes that connection.
All right. You mentioned Farmbrook on several occasions. Of course, Farmbrook is not a plaintiff here. And so how are you parsing between two? You're saying that, I believe that as you set forth in your response, and you're arguing here that Michigan Comprehensive provided the medicine or the injections that were Farmbrook, correct?
You cut out, Judge. I didn't hear what you just said.
All right. I was asking about Farmbrook, and of course, Farmbrook is not a plaintiff or a party to this proceeding. And so I'm trying to see how you're parsing between the two. It seems that you're saying that the treatment offered by Michigan Comprehensive was related to the Farmbrook treatment, and that the only thing provided was the injections that were ordered by the doctor under the Farmbrook intervention entity. Is that correct?
No, that's not correct, Judge. It was Farmbrook that provided the epidural steroid injections to this patient. Michigan Comprehensive only provided the anesthesia during those procedures that were provided by Farmbrook.
Mr. Ashew?
If I may respond, Your Honor.
And Judge, I might also just in passing, this Mr. Ashew is familiar with this because Farmbrook had its own cause of action against the city of Detroit. Mr. Ashew was involved, and that case settled, and Farmbrook got paid in part for those epidural steroid injections. So all this plaintiff did was provide anesthesia during those procedures that the city of Detroit has paid for now.
Your Honor, if I may,
Yes, Mr. Asher.
yes, as the court correctly pointed out, Farmbrook is not a party to this case. I'm not sure why plaintiff is so reliant on the records of an entity which is not a party to this case. Plaintiff's response explicitly states, and I quote, "Plaintiff is an entity that is limited to providing anesthesia and has nothing to do with the examination of or the treatment provided to the patient for the underlying motor vehicle injury." That's plaintiff's own statement in their response. Dr. Dillon was questioned during his deposition as to whether there was a referral from Farmbrook Interventional to Michigan Comprehensive Pain and Spine, and he said no, that was just an additional service. So this notion that it was somehow prescribed, there's no evidence that's been provided to defendant that supports that assertion. Further, when we talk about the hearsay objection, it's about the statements not related to the treatment and diagnosis. There's a long list of case law that's cited in defendant's reply brief supporting that contention. Furthermore, plaintiff attempts to use the fact that there was a resolution of another case in contravention of MRE 408, which explicitly precludes the resolution of other cases as evidence of liability in later cases. He's presented no factual basis that this is actually related, that the 2020 treatment was actually related to the 2016 motor vehicle injury. You see nothing from claimant that she actually received the treatment or that the treatment was required as a result of the 2016 injury. Plaintiff also attempts to say that Dr. Dillon said, yeah, there's a causal connection between the accident and the treatment, but he's not qualified to render such an opinion. He can only diagnose and treat. He can't tell you what caused an injury. He can only diagnose and treat. So I would ask that the court disregard that assertion and look closely at the testimony that's provided by defendant, cited in defendant's brief, and to take the motions under advisement and render appropriate opinion.
So it sounds, I guess, kind of what seems to be a little bit intuitive here, maybe it's not. And that is that there is a claim here because again, the motion sounds and there is no factual formulation that could cause the case to survive, and that the defendant is entitled to granting of summary disposition. It seems that that this case has to do with anesthesia that was provided as a part of another treatment that is claimed, that other treatment is claimed to be in relationship to the automobile accident that is arguably the subject matter of this dispute. Why does that not create a exact question that needs to be litigated here?
If I may, Your Honor, because there's no evidence that it was actually required or medically necessary. As plaintiff stated, she began treating with Farmbrook in 2018. So 2 years pass and there's no treatment from Michigan Comprehensive Spine, and all of a sudden they're providing this additional service that is not requested by the plaintiff, that doesn't appear to be medically necessary, and they want us to pay for it. But there's no evidence that it actually relates to the accident. The doctor didn't testify, yeah, there was no intervening causes between 2016 and 2020. So there's a lot of speculation here that plaintiff is attempting to rely on. And there's a long list of case law that says speculation is insufficient to create a question of fact.
The judge, there's no speculation here. The doctor testified on page 36. Mr. Ashew asked, okay, as it stands today, do you personally have any factual basis to believe that the treatment was occasioned as a result of a motor vehicle accident? And the doctor answered, I believe so. That's not speculation, that's a fact.
All right, And I know the argument there is that he was not competent to testify as to that particular fact.
And also, Your Honor, not to cut you off, but there is another part of that when I ask what the belief is based upon, and he can't provide anything concrete to support that belief. That's cited in defendant's motion on page 9.
All right, so what I will do is I will take the motion under advisement and I'll make a decision on it. So I'm gonna want to have you back here just for me to run my decision, and we could do that maybe next Thursday.
Oh, okay, 24th.
The 24th at let's do it at 10:15.
Your Honor, I do have a conflict at 10 o'clock on Thursday. Another motion in another courtroom.
All right, so if I set it at 10:30, could you pull that off? You think?
I may be able to. I probably could. I don't know if you could do it earlier than 10. I could do earlier than 10 for sure.
We'll set it at 9:30.
That works.
Works for you, Mr. Jackie?
Yes, Judge.
And Mr. Asher, if you will get that, the other document over to me.
It should be on the second floor, Your Honor, if you haven't received it already.
Yeah, that makes it that much more interesting.
Yeah.
Hopefully.
I hand delivered it, Your Honor, so I know it's there.
Well, I don't doubt that it's there. I just know that it's not here. That's the problem. All right. So we'll try and get our hands on this one. All right. Thank you. I'll see you on Thursday, the 24th at 9:30.
Thank you, Your Honor.
This is case number 21150058. This is Carlos Williams versus Metropolitan Group Property Casualty Insurance Company. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Richard Brewer, P31124 on behalf of plaintiff.
Thank you, Mr. Brewer. Good morning to you. For the defendant Metropolitan Group, your appearance, please.
Good morning, Your Honor. Monica Rossi, P61916, appearing for the defendant Metropolitan.
All right, thank you, Ms. Rossi, and good morning to you as well. Looks like I do see that there have been some exchange of witness lists and things along those lines. Where are you with regard to discovery in this matter at this time?
Well, Judge, actually, we did go to case evaluation on the 8th of this month. The accept reject period is not up yet, and the matter case filed for, well, I won't discuss the number, but I don't know what the parties are doing with respect to that case evaluation at this point.
All right, so that will need to run its course. And how much more time is left on that?
April 5th is the deadline, Your Honor.
So why don't I bring you back? Shortly after that, maybe the 11th.
11th. Well, it is alleged that I have a trial scheduled that day, Judge, but it remains to be seen if that's going to happen.
We could do it
The 14th.
Well, we could do it the 14th.
14th?
That's better for us. 4/14.
Okay.
Very good.
At 9:30, and I'm setting it for review on that date, and then we'll maybe talk about what else is needed if the case is not resolved.
Very good, Judge. Thank you.
Sounds good.
Thank you. Good day to you.
All right. Thank you. Have a great day, everyone.
This is case number 21-147838. This is Preferred Rehab Care versus City of Detroit. Matter is before the court. Looks like on a motion for partial summary disposition. Council, your appearance, I don't see anyone else here.
Yes, Your Honor. Attorney Jane Mills for defendant City of Detroit. I called the plaintiff's attorney this morning and they did not have it on their calendar and I told them somebody needs to be here. And so I don't know what the court wants to do. My information on this case is that we have resolved the claims of preferred for Jones and Henry, but there will be no payment for singles. Obviously, I can't argue any motion if opposing counsel is not here. So what does the court suggest?
Well, I will go ahead and set a date on it. What was their response when you told them that somebody needed to be here?
I didn't even get a hold of an attorney. I got a hold of a paralegal who says, oh, we don't have this on the calendar. So I'm like, somebody better show up.
All right.
And off the record yesterday, Your Honor, yesterday I was here for that very long hearing with the husband and wife. That was very enjoyable.
I don't know, but I have to tell you that you're not the only one that seemed to enjoy that. I don't know if that's good or bad.
Are you a lawyer was the tagline yesterday, so.
Several folks have said that that was just what they needed. A break in the ordinary, so, well, it gets strange sometimes, that's for sure.
I would
All right,
suggest if the court is inclined to put it off for a week so I can, I don't want to do a ex parte thing and let's get this done, if that's okay.
All right, yeah, I'm gonna go ahead and send it over, let's, read it. What was that, the 24th?
Let's see, the 24th
March 24th.
is okay. Trying to see if I have somebody to cover it, but we'll get it covered. Let's see.
If you want to do it.
What time you're on?
23rd.
Oh, the 23rd, 23rd is not good.
None of those.
Oof.
We got big-
So not the 22nd.
Nope. Yeah, bench trial on 21st.
Okay. So, yeah.
If the court made us come in early, like 8:30, because this should be quick. Or well, let me stop talking. Whatever you want, Your Honor.
I mean, that's all you want to do on the 21st.
So you were talking about the 8:30 on what day were you asking?
If you're inclined, 8:30 on the 21st, which would be before your trial. Because it may be just putting something on the record if you want, Your Honor. Or 9.
What do it now?
Again?
4/21, 22 at 9 a.m.
4/21, 9 o'clock a.m. Okay, I'll make sure plaintiff attorney is notified. Thank you, Judge.
Thank you. Appreciate it.
Bye-bye.
Alrighty then.
Is that 3/21?
Yeah, you got it for the 21st.